I will be discussing in my 5 minutes the applicability of Chapter 4022F as regards the validity of the burial permits. And my co-counsel, Robert Bangirotti, will be discussing the Emerson College case and its progeny.
As a factual matter, are all three of these communities, Taunton, Attleboro, and New Bedford, had they voted to accept Section 22F?
Both Attleboro and New Bedford did vote to accept 22F. I'm sorry that I do not have any information on Taunton. That matter was argued in New Bedford's trial brief as well as in the appeals court brief, but was not addressed at all by the appeals court below. It is our position that the burial permits are mandated under 11445 and therefore fall squarely within the very terms of 4022F enacted by the legislature in 1991. It is a permit issued by a municipal board pursuant to statute, and as was found below, both at the Superior Court and upheld by the appeals court, the costs were determined to have been reasonable. It is our position, therefore, that as a result of the fact that all of the elements required by 22F were shown to have been in existence, 22F is controlling in this matter, and therefore the permit fees are valid.
So how do we, I mean, I follow that line of reasoning, and in many respects it seems clear and persuasive. But is it possible that, so you're suggesting that we don't have to deal with Emerson at all?
Yes,
Emerson
I am.
Just relates to some other universe of...
A more interesting, perhaps, universe. Mine is rather cut and dried.
Okay, so if let's assume this. Let's assume that the city determines to impose a trash fee on every resident. Every resident, trash fee, $200 a year. Whether you put your trash out or not, there's a trash fee. That would, you'd have to look under Emerson to sort of figure that out. Whether that was
That's right. That would fall outside of 22F. A trash fee, in our interpretation, would not be pursuant to statute or regulation.
But this falls in a separate line. This is a permit that the city is required to issue by a state regulatory scheme.
That's right.
And 22F gives you the authority to charge a reasonable fee.
That's right.
To recoup the cost of that.
That's right.
End of case.
End of case.
What if the fee, but what if instead of $10 or $20, you were charging $65,000?
Clearly, then, under the very terms of 22F, that would not be a valid fee.
And the person who has to pay it could challenge it.
That's correct. But the evidence below, as upheld by the appeals court, was that it was.
I understand that. I just was.
And 22F was, as I understand it, passed after the Emerson case.
Yes, it was. Some 7 years after Emerson.
But in this case, you also say that there is a particular benefit that the undertaker gets in this case.
Not only the undertaker, but also the family of the bereaved. And I believe the amicus brief of the Attorney General is actually quite persuasive, I thought, on this point, discussing the need for the family, the grieving family, to be aware that the remains have been properly disposed of, that they are where they were told by the funeral director that they would be. It's a 3-part form that the communities use. It's a state form. It's a state process, state regulation, and the communities don't have an option. But there is a benefit, and the class of individuals are families of the bereaved.
So under your 22F analysis, reasonable relates to the overall cost of administration.
Of the burial permit system.
So that's why Judge Boxford's hypo would not work, because that would exceed the cost of administration.
That's right. That's right. Since I have the less sophisticated argument, I'd certainly, unless the justices have any additional questions, I'd like to cede my additional time to my co-counsel.
Thank you, Ms. Shaw.
Thank you.
Good morning, Mr. Mangiolati.
Good morning. May it please the Court. I am here to speak about the Emerson College case, and we suggest that this case gives this Court an opportunity to comment on Emerson College and provide additional guidance to practitioners. We respectfully contend that the appeals court made two fundamental errors in its analysis of your decision in Emerson. First, we contend that Emerson, while it sets out three factors, Emerson did not say those three factors were a rigid all-or-nothing test. Emerson clearly uses the language factors to be considered in an analysis, but the appeals court in this particular case actually used the term test. I think it's not a test. I think that the cases that we've cited in our brief indicate that courts tend to pick and choose.
Are you saying you could just pick one of the three factors, and if there was enough there in that one factor, that would resolve it?
Yes, Your Honor. I think that particularly with respect to regulatory fees, the jurisprudence has indicated a much simpler approach, one that says that
and so you're saying that's where the appeals court went wrong, because they looked at all three factors.
I think that they were right to look at the three factors, Your Honor, but I don't think they were correct when they rigidly applied it to come up with what seems to be an unusual decision that says a mere $10 fee is an unconstitutional tax. So that while I think it might be prudent to look at the factors, I don't think all three factors have to be present in equal measure for the fee to be legitimate.
Are you suggesting we should simply go, for example, with the Supreme Court of Hawaii in the Medeiros case, where it simply says we adopt the following modified Emerson College test? One, in determining whether a charge is a fee or a tax, we analyze whether the charge applies to the direct beneficiary of a particular service. Two, is allocated directly to defraying the cost of the service. And three, is reasonably proportionate to the benefit received. Would that be your model, you think, we should adopt?
Your Honor, we of course cited the Medeiros case, although not for the proposition that it is the test. We cited Medeiros because it's an example of where courts have tended to pick and choose among the Emerson factors. We also cited in the same section of our brief the Sinclair paint case, which came at the problem from an entirely different perspective. And in that case, the court said that particularized benefit was not an issue at all. Whereas in Medeiros, the state of Hawaii said, because criminals don't get any particular benefit from the prosecution, then the purported fee was a tax. So you had two very well-reasoned cases in which one instance the Sinclair court said, we're not going to apply the particularized benefit case, whereas in the Medeiros case, the court said that the particularized benefit case is the controlling factor, or the particularized benefit factor is the controlling factor. I think that the unifying theme in all of this jurisprudence, Your Honor, is that the purpose of the tax cannot be to raise revenue. And if you look at the three cases, in only three cases cited by my brother, where a Massachusetts court has disallowed a fee, each of those three cases were attempts by municipalities to come up with a creative way to raise revenue.
You put a fair amount of stock on the point that you see Emerson as a proprietary fee, and that regulatory fees really are a very different kettle of fish.
Yes, Your Honor. I think, as I'm about to point out, that the three cases where the fees were disallowed were all proprietary fees, not regulatory fees. In Emerson, the city of Boston was trying to raise $12,000 from Emerson College for service, a proprietary service, for which Emerson never paid any money before. So again, it was clearly to raise money. Secondly, Berry versus Danvers. In the past, in that community, someone could get a sewer hookup for $10. But after the regulation in Berry versus Danvers was passed, 7 condominiums cost $58,000. And then finally, the other case where this court, or rather the appeals court, turned down a municipal fee, it was in the Greater Franklin home builders case. Again, it was a proprietary fee in a sense that they were charging new homeowners for the cost of education.
Well, take my trash fee case.
Yes,
a lot of cities and towns, there's a trash fee. Everybody has to pay it. It used to presumably be included in your property tax, but it's now been pieced off. Presumably the town has a contract with some trash company, and this fee defrays the cost of that. That would be what, proprietary?
Yes, Your Honor, because the city is operating the trash disposal operation. And if a trash fee was primarily intended as a way to raise money, if your trash fee was not $200 but $20,000 a year, then clearly that would be an inappropriate fee.
So you would say what? As long as I, as a resident, get a benefit and the fee is proportional to the service I'm getting, then that would be a fee appropriately.
Yes, Your Honor, but I caution, that test applies primarily for proprietary fees, like a trash fee or a water fee or a mooring fee for a boat, where you're getting something from the community. The whole set of different standards apply when it's a regulatory fee in the exercise of the police powers, which is what we have here, of course. We have a public health and safety concern of keeping track of the bodies. And, Your Honor, in our brief, we cited a number of cases in which our courts, prior to Emerson, and all other courts throughout the country, when examining a regulatory fee, simply asked, is this a legitimate exercise of the police power? And I think it clearly is here. And secondly, is it reasonably calculated to recover the cost of the program? And I think that's clearly the case here, too. And we've cited a number of cases all over the country that have looked at regulatory fees and reached that conclusion. And I think that it's important to understand that regulation, by its very nature, is directed toward the public benefit.
But how is that different than, how is the analysis any different than the proportionality test under the proprietary fee?
Oh, I think it's the same.
Okay.
I think it's the same. All I'm suggesting is with respect to regulatory fees, the emphasis that the appeals court placed on choice and particularized benefit was misplaced. The proportionality was the fee commensurate with the cost. I think it's the same in both. I think that whether it's a proprietary fee or a regulatory fee, cities and towns cannot be using a fee as a means to get around the limitations on taxation.
But I mean, even if you look at particularized benefit, I think there's an argument that Ms. Shaw made that not everybody has someone who dies within this community. I mean, so there is a benefit to those, to the family and to the undertaker
As my
to get the permit.
Thank you, Your Honor. As my co-counsel pointed out, I think that all of the briefs, particularly the Attorney General's brief, put a great deal of emphasis on the particularized benefit that both the families and the undertakers receive. I think the rest of the case law suggests that the particularized benefit, at a minimum, is the ability to engage in a regulated activity. I pay the Board of Bar Overseers. My fees go to police lawyers, and that's for the benefit of the public, but I have the privilege of practicing law accordingly. And similarly, the choice factor is the same. I could choose not to be a lawyer, but if I choose to be a lawyer and it's a regulated industry, I have to pay the fee. The fact that the people have no choice in dying, I think is a misleading factor in this case. I mean, I may get a toothache, and I really don't choose to have a toothache, but if I go to the dentist, I expect that my dentist will be registered by the state, and that when he pays his registration fee, he passes that on to me, his patient. So I think the analogy is sound. I think that as a result, in these circumstances, the appeals court's imposition of a rigid and inflexible particularized benefit and choice factor here was misplaced.
The more apt thing would be is that what if the city charged a permit fee to the dentist every time the dentist filled a cavity?
Well,
that's more apt to this, really. You're not registering funeral.
Well,
directors.
no, actually, the statutes, General Laws Chapter 112 and 114, assign to boards of health specific regulatory responsibilities to the funeral industry under sections 112, Chapter 114. 112 relates to the training and registration, but 114 relates to the practice. And I think that's a distinguishing fact here. The Commonwealth has assigned to cities and towns responsibility for regulating undertakers, not so with dentists. And the charges that we charge here are reasonable. Thank you very much.
Thank you, Mr. Mangiolati. Mr. Silva?
Good morning, Your Honors. Ending on an apt note, first off, my name is Martin Silva. I represent plaintiff appellant Paul Silva. The Board of Health does not regulate funeral directors. That is for the Board of Registration of Funeral Directing and Embalming. On page 13 of my brief, an opinion by the Attorney General makes that clear. All that boards of health can do is yearly send a card out instructing funeral directors practicing within the limits to certify that they are in good standing with the Board of Registration and Funeral Directing and Embalming, and they will then get a license. It's analogous to a food handler's permit or a permit to run a restaurant. They don't then charge an additional fee every time people eat there. Which was in keeping with Justice Cordy's point a little while ago. But in addition to the analysis, interesting situation here, we've got the Wyeth case from 1909, Wyeth v. Thomas, or Cambridge Board of Health, which stands for the proposition that you don't need a funeral director to procure a burial permit. Anyone can get this permit, conceivably.
But isn't it better to have the funeral director do it instead
Right,
of the
because they're
grieving family?
experienced with
Or,
this.
God forbid, if the family isn't grieving, and we have to make sure the person's dead, you need the medical, you need that, the certificate, the death certificate.
Death certificate precisely is the most important document with the death registration process. Statutes referenced and duties that need to be followed by funeral directors, being the de facto permit seekers here.
But if they didn't charge the funeral director, they'd charge the family.
Exactly.
And what's
Somebody has to pay the fee. It's like a toll booth. You don't pay the fee, you don't get to start the death registration process. Funeral directors, for the first half
and
of the
it's better to have the funeral director do it because they're calm, they're
right, absolutely.
removed
as
from the situation.
As opposed to unfeeling, dispassionate. There's a little personal offense that funeral directors can take with some of the language that the Attorney General says in his amicus brief. But the important concept being that it's the death certificate provided with the help of the family, naturally. The funeral director pulls in all the information, fills all that information out. That is the document by which families benefit. Putting into probate an estate and get inheritance, or put in for life insurance. The burial permit is not something that families, with all due respect, call the boards of health to find out where their loved one had been buried or cremated. The stub itself, and it's in the back of the brief, you'll notice there's no particulars as to where in the cemetery. The vernacular is such that it leads you to believe that the permit is the all-encompassing that triggers the death certificate. That's not the case.
But the cemetery cannot do the burial without it, right?
Precisely. It's a verifying mechanism, a small cog in the death registration process, which verifies to the superintendent of the cemetery or the crematory, saying, yes, a valid certificate has been filed at this municipality.
So it's a condition precedent to the burial.
It is. Precisely, and if you don't, if a funeral director serves a family and is not timely disposing of finding some way within the parameters of 114 to dispose of the remains, they can be subject to fine and imprisonment. There's, death itself happens.
But you seem to suggest that there's no benefit to anybody. The family needs it to get life insurance, probably a pension.
Yes, the death certificate, not the permit. The permit is a small cog in the recording process.
They need the permit to bury the body.
Right, but it's to simply verify that, within the context of recording.
They cannot bury it without, because the cemetery won't accept the body.
Right, so thus the force here, the involuntariness of needing the permit. But there's no benefit running from the permit itself, that small cog in the death registration process. So it's particularization which is not there. Everyone benefits equally it's not a question of if, it's when for all of us. You know, if you die, the fee will have to be paid if you happen to die in a municipality that charges this fee. It's interesting that as for the fact that this case was presented on an agreed statement of facts, and in colloquy, it's referenced in the brief at pages 58, 59, the judge made clear, and all parties agreed, that as to the first two prongs, they were violated per Silva 1, and the issue remains on the third prong. Emerson itself referenced, the wording is such, and it's very instrumental here, which is good law, it's helpful, it's not inflexible. There are many cases, all of which I can distinguish if we want to go through the time. It's a very unique situation here. But Emerson...
Before you get to Emerson,
Sure.
why don't you address Ms. Scholl's argument that we don't need to get to Emerson because Chapter 40, Section 22
Yes, precisely.
addresses it.
Thank you, Justice Gantz. That statute allows for fees to be charged, not taxes. If a fee so-called has the effect of a tax, then there's no way that it can be upheld. That's kind of like an enabling statute. It's like you can't bootstrap off that. Otherwise, they could charge fees for whatever they wish. Justice Cordy had mentioned again this trash fee. Everyone's got to pay. There's a Greater Lawrence case that was decided regarding trash fees.
Trash is a little different, though. Trash is a little different under Section 4022F because you need a license, permit, or certificate to collect trash.
Well, you know, the reason I mention that, though, is, you know, as you start to talk about proprietary...
I just don't know I don't know the answer to that.
No. But
and do you need a license, permit, or certificate to provide water?
You're asking me?
Yes.
Water rate cases are traditionally, you know, understanding of the fact that some people use more water than others. It gets to the proprietary user aspect. We only die once.
So you're saying 22F, it allows for the imposition of something, but whether it's a fee or a tax depends on the Emerson analysis?
Precisely, Your Honor.
And if it's a tax, then 22F doesn't permit it, or it has to be done differently, or what?
Well, it has to be a fee. And the Emerson test is the best thing we've got right now to determine a permissible fee. Emerson, when it finished analyzing the first two prongs, finding that they had been violated, they go on to say, although we need go no further to sustain the conclusion that the charge is not a fee, we note that additionally the monies were put to the general revenue fund.
Let me ask you this. Did the city need a permit to provide firefighting services to Emerson? No. I mean, the answer is no.
Because it's
I mean,
part
that's
of essential government function to provide fire protection, just as it is to provide education, just as it is to make sure that bodies are properly disposed of and used to everyone's benefit.
Mr. Silva, why would we not say that the way you test the validity of the imposition of a cost, fee or tax under 40 Section 22F is whether or not the charge is reasonable? In other words, if it's not reasonable, and there's no claim here that it's not reasonable, it is mutatis mutandis a fee.
Right. Well, it can be reasonable, and we ultimately, conceded that point.
Correct.
Precisely because we felt the third prong, being the least analytical, least important, when the first two prongs are found to be violated, the weight in considering all prongs, opposing counsel would have you totally disregard the first two prongs. I'm sorry to be circular, but
Isn't this like a building permit?
Except that not everybody can live in your home, and you get an actual inspection. There's no inspection done.
No, I'm talking about a permit to build a house. If a contractor wants to build a house for somebody else, he has to go to the building inspector, apply for a permit, pay a fee, and show a plan. It's sort of the equivalent of the medical certificate. And the building inspector looks at the plan, makes sure that it's essentially in compliance with the building code, and then accepts the money and issues the permit.
Well, the only bit of inspection is enough to glean, not so much verify. They don't know whether the information on the death certificate is correct. If there is, in fact, an error, it's the funeral directors or the permit seeker that has to then correct. It's a...
Well, there's got to be a cause of death. It has to be stated on their death certificate. It's got to be signed by, take it, a doctor?
Yes, a doctor. A nurse pronouncement is not enough. That just allows for timely
Yeah.
removal of the remains if the death takes place at home or in a nursing home.
Mr. Silva, may I ask you this question? The briefs that have been filed by the two defendants here are briefs filed in the Supreme Judicial Court. Was the argument with respect to 40 Section 22F made to the appeals court?
I don't believe so, Your Honor, because Silva had treated that in Silva 1, Silva versus Fall River, almost in footnote fashion, saying something like they're not concerned with whether or not cities and towns can charge fees, but whether or not, in their effect, it would act as a tax.
Mr. Silva, with respect to that question, though, the reason that it would be impermissible if it is classified as a tax is because is that cities and towns don't have the power to tax, correct?
Correct, yes.
So if the legislature gives, through Chapter 40, Section 22F, the power to impose a fee, does that not take care of it?
Well, then...
I mean, so
Well,
the
I
label
guess the
becomes-
problem there is if you have a situation like here, that it so clearly violates the Emerson test, at what point is the sliding slope, we all drop off, such as to make the Emerson test totally moot and useless?
Well, isn't the other question then, if it is a tax, then it's got to fit the constitutional parameters of a tax?
That's correct.
Am I wrong about that?
No, you're not.
I may be.
Well, and it's interesting, some of the older cases cited 100-plus years ago were prior to the amendment in the 60s, Article 89, Section 7 amendment that kept prevented cities from charging taxes.
Right. Well, but the point is, if the legislature authorizes the cities to impose a tax, presumably that would authorize it in one sense. Then the tax, I take it, would have to comport or comply with the Massachusetts Constitution with respect to taxes. I can't remember what the terms
And
are.
the easiest way-
This, that, and the other.
Proportionality, yeah.
The easiest way for the legislature to do that is to list a charge for, or, create a charge, enumerate it amongst the others in General Laws 262, Section 34 lists more than 50 fees that may be charged. There's 70 sections altogether in 262. The Secretary of Administration and Finance, CMRs, are referenced also by the Attorney General. There's over 1,400 to 1,700 fees. They can look to the legislature to have them charge, in effect, a tax, a death tax, which is what it is. That's its effect here.
Could you clarify something for me? Your brother was telling me that when we talked about the Emerson factors, that you look at the factors but not rigidly. You can focus in on just one of the factors. And I take it your position is you have to have all three factors in place.
You really do, Your Honor. Yes. You have to weigh all the analyses. If it's not truly a regulatory fee, there's no entity being regulated. If a person other than a funeral director is that proper regulation? And if there's absolutely no choice in the matter, or such that, and if there's no proprietary or use, that's what the other cases referenced from Hawaii actually do. They first try to distinguish if it's a user fee, then one test is utilized, the Medeiros check test. If not, if it's regulatory in nature, then a San Juan cellular test is used. But the Emerson test has been useful for this court it's still viable. It has helped in valid outcomes, naturally. But to distinguish, say, regarding nuclear metals, the funeral directors nor the families of loved ones who have deceased are not the generators of the death. There still has to be some type of choice. There has to be some type of benefit running, and we ask the court to affirm the appeals court reversal below, and ultimately make clear to the Commonwealth that this is an illegal tax such that all cities and towns who charge stop doing so.
Thank you, Mr. Silva.